Some of you might be familiar with the Endroy case in 2009. That's one example where they specifically referenced FPIC. To date, most of that jurisprudence and all of it that is specifically references FPIC is relevant for indigenous communities in particular, peoples. However, I think it will be interesting in future to test where the African Commission is going to stand now that they have issued this resolution which talks about FPIC more broadly. They also have cases, the famous Ogoni case in Nigeria, where they talk about the right to participate in environmental decision-making and protection from forced evictions. And then one other body, the Pan-African Parliament, also 2012, so note that these are all sort of recent declarations. They issued a statement urging for foreign direct investment rules in land and natural resources, and they said, including local community consultation and FPIC. So again, actually even broader than just the mining sector, talking about land and natural resources across the board, and not specifically hinging it to indigenous communities. I won't go into the details on the African Mining Vision. I think that's already been covered in the morning. The report itself actually does not reference FPIC. It talks about public participation in mining projects and participatory decision making, which I think is, it goes a bit farther than simple consultation, but not quite as far as FPIC. However, one interesting point, some of you may have seen that there was an action plan that was adopted in 2011 by the African Union Conference of Ministers responsible for mineral resources. And that action plan does make a specific reference to FPIC, saying that states should domesticate FPIC for mining communities. And it also talks about capacity building of governments, civil society, communities, and companies to make informed decisions. So I think it's another tool that's sort of relatively new, that's now being tested. I think this actually gets a bit lost in the document, specifically, or particularly since it's not referenced in the actual report. So it might be interesting for civil society to call attention to that with their governments. You have an obligation here. This is the direction things should be going. But just to say that the African Commission on Human and People's Rights with the ILO issued a useful report providing guidance on some criteria for identifying indigenous communities. And then I've listed them up here, and they've gone as far as to say, we don't interpret indigenous populations as first inhabitants as we would in the Latin America context, for example, but rather communities that self-identify as indigenous, have a special attachment to and use of traditional lands. FPIC has been used in the indigenous rights movement for many years. These two treaties are ones that have been used for many years in Latin America in particular to argue for the right to FPIC. So the United Nations Declaration on the Rights of Indigenous Peoples, which has a specific reference to FPIC for indigenous peoples, and the International Labor Organization Convention 169. So, unfortunately there's only one country, Central African Republic in Africa, that has ratified Convention 169. So that's where it applies specifically to indigenous and tribal peoples. It's interesting to look at the policies, relatively new policies, just beginning in 2012 for the International Finance Corporation. So the International Finance Corporation, or IFC, is the private sector lending arm of the World Bank. And in the process of the revision of their standards, they've adopted a new policy. Their policies are environmental and social protections for the clients that they fund. So for example, in your country, there's a large mining project that has gotten funding from the IFC. The company implementing that project would be obligated to respect the environmental and social standards of the IFC. And if not, you could appeal to the compliance advisor ombudsman of the IFC, saying that they've broken their own standards. So it can be a direct advocacy opportunity if you have a project financed by IFC in your country. But even if you don't, I think it's useful because dozens of corporations use the IFC environmental and social performance standards, these safeguards, as a model. The Equator banks, for example, dozens of banks adopt the performance standards. So if you want to kind of put it out there as an example of practice, you could do that regardless of whether they have a presence in your particular country. So in the context, they have in their new standards, in the context of indigenous peoples, they have a separate standard on indigenous peoples. They make an explicit reference to FPIC. And one thing I think interesting about that is that that process requires good faith negotiation It requires documentation of a mutually accepted process, which is really critical. It's not just the client or the company deciding this is how I'm going to consult you. They need to get the agreement of communities on how they want to be consulted. And there needs to be evidence of agreement. Less sort of known, I think, is the policy that they have for non-Indigenous communities. And this applies to any project with potentially significant adverse impacts. So I would argue that just about any mining project or oil project is likely to be categorized as having significantly adverse impacts. Sometimes I disagree with IFC's categorization, but I think that as civil society we can push back and argue for that. And in those contexts, those particular projects, the IFC requires informed consultation and participation, leading to broad community support. And I don't think this idea of broad community support, which was actually invented by the World Bank, should be confused with FPIC. It's not the same. It's not about Indigenous ownership of the decision-making process. At the same time, I do think we can use it to push the IFC and say that they need to go farther than simple consultation with communities. They need to actually make sure that communities support the decision that's being made regarding the project. One of the most obvious costs is the direct cost of delays from project implementation if there's protests, stalling of the project. And there was an interesting study from Harvard and Queensland University, this was 2011, that found mining projects can lose $20 million per week from conflict delays. $20 million a week. So when you're talking to companies about the cost of consultation and they say it costs too much, think about what it would be like to lose $20 million a week. Social conflict, this is in a separate study from the Munden project. Social conflict can increase operating costs 29 times over a normal baseline scenario. And then we're all very familiar with Nigeria. I have a picture there. Another recent study that said that Nigeria lost up to 800,000 barrels a day as a result of the violence and conflict after 2005 in the Niger Delta. So in addition to these sort of more obvious direct costs, there's also the reputational risk. So I have a picture here from Peru. The signs, these are some of the protesters around expansion of a mine that was called Cerro Quilich. And they're saying, say no to gold, respect life. And at the time when this protests were happening, Newmont, the US company that was operating in the area, their stock dropped 7% just during those 2 weeks of protest in Peru around the Cerro Quilich project. So it can really have an impact on headquarters as well. There's also the risk of project abandonment. And then the Harvard and Queensland study that I mentioned earlier had an interesting finding that one of the most underestimated costs is actually staff time lost managing conflict. Because when you have people that are higher level executive management end up spending a lot of their day trying to deal with these conflict issues, that can also have a cost which sometimes flies under the radar screen, but can be quite significant. This is a summary of findings from a report that we did in 2012 that's called the Community Consent Index. So this report looks at the public positions of 28 mining and oil companies around issues of community engagement, consultation, and consent. We have at the top bar, you can see companies that have an explicit commitment to FPIC. I should note that for these particular 5 companies, the commitment is for Indigenous peoples, projects that impact Indigenous peoples only. There's another company that we became aware of their policy after the release of this report, De Beers, which also has an explicit FPIC policy, which applies not only to Indigenous communities. So that's the first that I know of where they've openly stated that the policy applies to both Indigenous and local communities. The second bar looks at companies that talk about social license to operate. So that's a term. If we have time in the Q&A, we can dig more into that. I would argue that doesn't go as far as FPIC, but is somewhere above the more basic idea of just engaging with communities. The references to social license or community support are not specific to Indigenous people, so that's one advantage. And then finally, community engagement. These companies at the bottom, Vale and others, which have sort of a much more watered down commitment in terms of their engagement with communities for the moment. And then there's others, some of you might know them from the countries where you're working with that don't have any policy at all and are not included in the report. So we're going to do another version. We did this report in 2009, and there were only 2 companies that had FPIC commitments. We're hoping when we do it again next year we'll see a host more. And we're trying to do a lot of outreach to companies now to convince them that they should develop policies before that report comes out. And one thing that's going to help us is that the International Council of Mining and Metals developed a new policy just last year. It's relevant, again, specifically to indigenous peoples, but it does require all of their members to adopt FPIC policies by 2015. And when they talk about consent, it specifically says in the policy that communities should be able to give or withhold their consent to a project. So, that's useful, and we're going to try in our conversations with companies to really push them that this should be something that applies beyond indigenous. But for the moment, ICMM does not have as strong language in the context of other communities. They talk about diversity of participation in consultation in all stages of development. So, participation, they get partway there. And they talk about the environmental impact assessment process and recommend that it be participatory, transparent, and address human rights impacts. So I mentioned I'm not going to go too much into national laws, and the report doesn't go into a lot of detail, but just a few sort of contextual comments on national laws. One, that laws affirming FPIC are uncommon at present, not just in Africa, but globally. And most of the laws that exist are in the context of indigenous rights. So Tanzania's law, for example, specifically says that they require, they say that the government can take lands when there's a public purpose, and they specifically say that mining and oil projects are considered a public purpose. So, that's sort of a departure from the traditional idea of what would be a public purpose project, a national park or a road that the public actually benefits from. In this context, it's an economic development project. And governments are now sort of expanding this understanding of public purpose so that they can become even more powerful in terms of their ability to take local lands. And finally, just to touch on environmental impact assessments, this is one area of the law where we often will see reference to consultation or public participation. Generally, they are required. Some include public participation requirements, and here's just a few examples. In Ghana, they require public hearings before issuing environmental permits.
And I think it's important when we do our advocacy that we look for evidence. We look for evidence that we can use, because some of the times we are talking to ourselves. We are reminding each other, of course, it's important that, these are the things that have been taken away from us. But there are times when we have to talk to those people that have taken away those rights. And I think what Emily has shown us here is that it's important to do some research so that we use the right language. And there is clearly, legislation in some countries. There's clearly, a broad range of tools that we can refer to in terms of trying to get our rights back. So thank you very much, Emily. I'll call upon the next speaker so that we finish up with the speakers before we address our questions to them. And I'll ask, unfortunately, the next few speakers to maybe try and be a little brief. I know there's a lot of detail. So may I ask Matome, Kapa, and Tebo Josepo Hoti? They're going to talk about the Vatlabine Foundation versus Blue Platinum Ventures, and I understand is it a court case? Because one of the other things that we've been striving to do in the last 4 years is to show communities that you can get this power back, you can get some legal recourse.
For a mining company to operate, it needs a water use license as well. And in this case, we found that there was also no water use license, and this is one of the non-compliances this company was busy with. And also Section 151 of this National Water Act, it says that for a first-time offender, you can pay a fine or be sent to prison to not more than 5 years, or if it's your second time offending, it can be time not more than 10 years, or you can serve both. First-time offender, as a first-time offender, you can serve both time that is not more than 5 years and also pay a fine. Usually when working with the communities, you need information to know what is it that you are fighting against, what is it exactly to the detail that the companies have and how they are affecting their environment. So in order to get that information, we use the Promotion of Access to Information Act. Now this legislation allows us to go to a public body and request any information, whether it's a water use license or any other information relating to a mining right and so on of such company. And I will now hand to my colleague to tell about the criminal charges in these cases, and I will come further later on and tell about the lessons that we learned from this case.
Firstly, what happened is the Batlabino community, they established the Batlabino Foundation, which is a non-profit organization that works for the advancement of the Batlabino community. So through the Batlabino Foundation, they approached the Center for Environmental Rights, seeking for legal advice. And in order for the Center for Environmental Rights to gain more insight as to what's going on with the case, we applied one of the legislation that my colleague was just talking about. We used the Promotion of Access to Information Act, which is also known as PIA for short. We sent PIA applications, PIA applications to the Department of Mineral Resources, the Department of Environmental Affairs, the Department of Water Affairs, and to Blue Platinum itself. In sending this PIA request, we were trying to establish whether the Blue Platinum have all the requisite authorizations in order to mine. And through these PIA applications and our engagement with the relevant departments of Blue Platinum, we were able to find out that Blue Platinum did not have a water use license, which is required by the National Water Act. We found out that Blue Platinum were awarded a mining right in respect of 2 particular sites. However, they extended their operations to 2 other sites, therefore violating the MPRDA because they were mining the other sites without the mining right. The MPRDA also requires, as my colleague has just spoken to you about, it requires, before someone can commence mining activities, they're supposed to conduct environmental impacts assessments and compile a document called the Environmental Management Program, which is also called an EMPR for short. The EMPR sets out, amongst other things, how you are planning to manage environmental impacts and how you plan to rehabilitate after you finish mining. What NEMA does is it sets up a list of certain activities that could be potentially harmful to the environment, and for one to conduct those activities, you need to obtain an environmental authorization from the Department of Environmental Affairs. We assisted our client to lodge a complaint with the Department of Mineral Resources, telling them, setting out the facts. And then after a year and a half of extensive engagement with the department, at the end of the day, they wrote a directive to Blue Platinum, telling Blue Platinum to cease all mining activities and start rehabilitations. What happens, in response, Blue Platinum spent a significant amount of time making promises to us and to our client that they will start rehabilitating, they are conducting studies and so on. And then after some time, when we realized that they're not going to keep these promises, we went back again to the department and we engaged extensively with them. And then we were telling them, can you please follow up on your directive? Can you please enforce the directive that you have issued to Blue Platinum? And then they did not help us. They did not enforce the directive. Nothing was done about that. So as the last option, as my colleague has just told you, the offences in these environmental offences also carry criminal sanctions. So we assisted our client to lodge a criminal case with the South African Police Services. And when we were doing the criminal case, we encountered a certain number of problems, and one of those problems being that the South African police officers, they're not very familiar with environmental offences because they're not faced with them every day. So we have had to assist our client to draw up his A1 statement, which was going to be included in the charge sheet to be submitted to the National Prosecuting Authority. The charges that were in the charge sheet, Blue Platinum directors, it was 6 directors were charged with 14 different offences in terms of the National Water Act, the MPRDA, and NEMA. And then the case was heard at the local magistrates court, and to our disappointment, we found out that the prosecutor agreed, the Blue Platinum, one of the directors, pleaded guilty to one offense. The offense was commencing a listed activity without an environmental authorization. And the case was heard at the local magistrate court, and sentencing of the case was last week Friday, 31 January. And the managing director, Mr. Mopone, was sentenced to 5 years imprisonment, suspended for 5 years on condition that he does not commit a similar offense, and that he has to rehabilitate the mining sites within by 30 April 2014. So we think this is a significant victory for both the environmental justice, for the struggle of environmental justice and the Batabino community, because this is what they were looking for in the beginning. They were looking for rehabilitations of their land, and to our knowledge, this is the first time a director of a mining company is charged in their personal capacity for environmental mining related offenses. I would like to hand it back over to Debo so that he can tell us about the lessons that we learned from this case.
The lessons that we learned from this case was like any other mining-related case. It was a difficult case. And secondly, the SAP and the National Prosecuting Authority, they don't have that experience of facing with such cases every day. So it was very difficult for them as well to do their job properly, because they don't have the necessary experience. And also, one of the lessons we learned is that when you go criminally after a director or after a company, then they start talking. They want to come to the table and negotiate. Because usually when you say you're going to have them fined, then they don't mind because they made a lot of profit anyway. They say, okay, it's fine. We just pay whatever their fine is. But when you go after them criminally, then it shows that it might impact on their corporate reputation as well, on the personal director's capacity as well. And also, usually in such cases, what the issue is in most cases is that the communities themselves, they are divided, they have major divisions. But in this instance, the community was at an advantage because it was a small, cohesive community and it didn't have many divisions within itself. And we consider this to be a victory because the sentencing is not everything that you get every day when you are faced with these cases.
Thank you very much, Center for Environmental Rights. I mean, that's the kind of story that I think we've been searching for. It shows that it's very important. I think the biggest lesson I learned there is that it's very important for communities to be organized, to be united, and to always know who the enemy is. Most of the time, communities end up fighting over the smaller resources that have been left behind. We can hear maybe 3 minutes of a similar success story of how communities took on a giant and won, hopefully. I hope your story ends well.
My full names are Thabo Lerotogi. I come from Lesotho. Actually, I have been moved by what the two gentlemen have just said. I didn't prepare any speech. I'll just talk from the top of my head, because really this is a moving experience. I am an advocate by profession, and I come from a place called Mokotong in the mountains of Lesotho. We have one mining company that is called the Lethen Diamonds Mine. Recently, we felt that as the community of Mokotong were being marginalized on the use of our resources. Our main minerals are the diamonds. And we got the best diamonds, I wouldn't say in the world, because probably some of you come from the place where you've got best diamonds in your places, but it's one of the best diamonds. We decided to form or to set up a forum called Maluti Community Development Forum. And we incorporated in such forum our principal chiefs, because we felt that it would not be proper to work with politicians. But the chiefs, being the owners of the people, we felt that yes, it was proper to work with them. One case or one example that I would want to cite where we feel that the mine is not working properly with us, or in a manner that we feel we are being done justice, is in respect of what we call corporate social responsibility investment. The mine built a lodge for the community. It's called Maloganen Lodge. And sadly, one of the general managers from the same mine decided to have what we call a joint venture. And in that joint venture, he had more shares than the people. It was a saddening story. And we had to lobby people so that we can march against, let's say, endowments. There are many things that I can cite, but I want to cite this particular example where corruption takes its toll. And we decided to go there and march against these people, but our story doesn't end very well ourselves. We haven't decided to take the matter to court, and probably the two gentlemen will assist us with the citation of this case, because I feel that it is really important so that we can use in our future endeavor to approach the court. Then we requested the Minister of Mining to intervene in this matter. But we haven't got the response yet. You can understand, ladies and gentlemen, it defeats the purpose of giving back to the community, whereby as a general manager of the mine, you want to give with the other hand while you take away with the other. It's an ongoing fight. Our forum has about 9 months or so. But, ladies and gentlemen, with these little experiences that I'm sharing with you, I'm saying it's good to see, or it's good to come to such platforms, such as Alternative Mining Indaba, where we share experiences with a gentleman like this. And indeed, I think from now onwards, I'm going to make them my friends so that we help each other with helping people in our societies. Thank you very much.
Thank you very much, Ndate. That was, well, this is why we are here, to make very important connections and to learn lessons from each other. I'd like to now call upon John Capel from Benchmarks Foundation, and I'll ask him to be very brief.
The Benchmarks Foundation, for those of you who don't know, monitor through evidence-based research and through community participation, what we call the Community Monitoring School, multinational corporations. and their social responsibility. And so we look at their CSR programs, their sustainability reports, what they say about themselves, and whether they actually live up to what they say, whether they meet international standards, whether they meet local standards per country. And all the time we find that there's a huge gap between policy and practice. So we know that all these companies subscribe to a number of international instruments, and they will tell you that they subscribe to the Equator Principles, they subscribe to the Global Reporting Initiative, the Global Compact, the John Ruggie process, and so the list goes on. And we know that policy in itself has a weakness. And when we started out 10 years ago, just to give a bit of background, when we used to go to events organized by the African Institute of Corporate Citizenship and the Global Reporting Initiative, and we'd have all these mining houses give these PowerPoint presentations, and they'd all look so good, as if they were really doing good work in communities. But from our first big study, we started to see a different story. And then from our work in communities, we really started to see a radically different story. And the idea that I have is not new. There's nothing new that I want to talk about today. We've heard from the Centre for Environmental Rights about litigation. We've heard from Oxfam, on various international instruments and how we can use them, and even that there's a business case for corporations to act more responsibly. But on a whole, what we're finding is that it's very difficult to go and litigate all the time for all the kind of issues that communities face around mining. And there's so many different mining houses. So we need to ask the question from, say, the Centre for Environmental Rights, if they've won a certain case, how do we use that as precedent in the law? How can we push that forward, etc. And we need to learn from each other. But the one thing that I'm interested in is how do we develop and push for an independent grievance mechanism? And we know that various international bodies call for this, but I first want to start off with what is the problem, and why do we need different ways and different avenues of redress for communities? And one, communities lack access and recourse to justice. I think this is very, very clear to us that that even if companies have grievance mechanisms in place, that they stop at the fence of the company, and the company also can't be the defendant and the judge in the matter. So there's a whole weakness in terms of that. I'm going to come back to that. And we know that governments have legislation in place. Like we know we've got the MPRDA. We know that mines must consult with communities before getting a license to operate. From our experience, what we see is that the mines might call a public meeting in a community. The community will attend on the promise of a free lunch, and they'll go to the meeting. They won't understand the issues that have been spoken about. An attendance register will be filled in. That attendance register will be taken to the Department of Minerals Affairs, and they'll say we've consulted with the community and the license is given. So we need to find ways to remedy these things, and we're hearing about different ways. We also know from the Minister of Mineral Resources in South Africa, Susan Shabangu, that mining is sacrosanct, meaning please don't interfere with investment in mining. These are the kind of statements that she's making, and she's delivering a keynote address at the big mine in Indaba, and I'm hoping to hear what she has said there. But because what we do know is that there are winners and there are losers in mining. And the winners are the investors and the shareholders and the executive management of these corporations, and the losers are workers and communities. And then we know that mining is very mixed up with politics in South Africa and elsewhere on the continent, and that we have the enrichment of a few elites that haven't put a spade into the ground in South Africa, we have Cyril Ramaphosa, who's a multi-billionaire through mining. We have Patrice Motsepe, Tokyo Sekwale, all these important political players. They're linked into mining. And so if we had to try and push for some kind of independent grievance mechanism, in the days of the early trade unions in South Africa, they pushed for a body called the Independent Mediation Services of South Africa, which mediated and arbitrated labor disputes long before we had the CCMA or bodies that do that in the country at the moment. But at that stage, I suppose the trade unions, and I'm sorry I'm messing up this mic, the trade unions and I think the corporations realized they had to do something because workers could go on strike and could stop production. And so it's around that kind of thing of how do we start to really push. But we know that there would be challenges. I don't believe that government and corporations would want to buy into independent grievance mechanism. Even if conflict is big around the mines. What we see in the platinum industry from Marikana and post-Marikana was a harder line by the mining bosses coming down on workers. We saw Harmony Gold CEO lock out workers last year in January, saying we're going to seize the agenda now, we're going to teach you a lesson. We saw Anglo-Said threatening to retrench 14,000 workers. And we can definitely see in the present strike situation, these companies are going to try and break the back of the workers and get them back to work and maybe break up any kind of trade union formation along that belt unless it's a compliant union that implements their wishes. So we can see that happening. We can also see that if we had a body like that, I just want to throw out these sort of challenges or problems, the precedents will be set and resistance will grow, I think, from the industry and from those elites that are connected into mining. And also resistance will go from governments who are trying to attract investment into their countries. But in a way, we need to have some kind of redress for communities, and we need a neutral third party that can oversee mediation and arbitration of disputes and make awards in terms of our legislation, but also in terms of international practice, also in terms of international guidelines. We know that the World Bank and the International Finance Corporation and the Equator Principles promote what they call company-level grievance mechanisms, but we know that they are useless because you can't be defendant and judge. That the World Bank talks about an independent and grievance mechanism and site-based specific sort of grievance sort of process. We know that Oxfam in Australia developed a mining ombudsman, but has not yet, from what I know, and Oxfam can correct me, managed to implement an independent grievance mechanism that is overseen by a third party. We know the same for the UN Special Representative, John Rudgie, and they talk about a credible company-level sort of mechanism, but I don't know what the word credible sort of means. And we know that ICMM, that are supposed to be here, also talk about credible grievance mechanisms at company sort of level. But for me, the challenge is how do we have different avenues of redress? We know that, yes, we can campaign, we can litigate, we can use the media, we can affect the reputation of these corporations, we can have protest actions, we can do advocacy and lobbying, and we can try and affect change in policy, we can do evidence-based research, but how do we start to find a way, a sort of common ground, maybe in the alternative mining in Indaba, to start looking for a way, a speedy way, an easy way to start challenging these corporations through an independent sort of body monitored by civil society, with corporations playing a role, with government playing a role, because I think you would need some buy-in there. But we would need one that addresses issues speedily and quickly. We would need, it would have to deal with individual and community complaints. It would have to deal with interest-based complaints, that is the interest of one group that's been impacted, let's say, upon by the mining house. It would have to also have a right-based approach to it. And we've heard cases here already today that communities have won. And it would have to be speedy and fast. It would have to be transparent. And it would have to be financed, I believe, by an independent fund contributed to by the mining houses. In the past, the Chamber of Mines in South Africa, around independent fund to capacitate communities, have said to us they would support it. Lonmin have said to us they would support it. Impala Platinum have said to us that they would support such a fund. But, you know, I'm not so sure they would. Because what we need to do is be leveling the playing field somewhat.